Hey everyone, I'm going to start in a moment. So, hello everyone. My name is Mary Ann Pizzatola. I am president of the New York City Organization of Public Service Retirees. I am here today to make an announcement that we won yet another case. We've been really excited about this. This was a very, very important week for us. It started on Tuesday morning when our attorneys notified us that we were finally granted our second appeal win in the New York State Appeals Court in the First Department. Another unanimous decision, which this makes the second time. So this is two appellate courts with unanimous decisions favoring the New York City Organization of Public Service Retirees, saying that the City of New York's efforts to strip us from retiree health benefits, our access to traditional Medicare and our city supplement, was illegal. We have been fighting this for almost 3 years, and our organization has been working day and night to make sure that we protected the people that entrusted their lives with us. And that is a very heavy lift. I want to tell you that we've been attacked from the very beginning, from the very people that were supposed to be looking out and protecting us. And the only thing that we were saying is, we made a promise. We were made a promise. That promise was, when you retired, you would have traditional Medicare and a senior supplement, and the city would pay for it. We were told that you would have a choice of healthcare. Those choices of healthcare came in the 40s when healthcare was first offered to the City of New York employees, with Mayor LaGuardia creating the very first healthcare plan called Health Insurance Plan, which is known as HIP today. Over the years, unions said to the city that they needed more choices, that the plans that they had weren't enough and didn't suit all of their needs. And over the years, the city kept adding more and more plans. As the years ticked on by in the 60s, it was actually the insurance companies that reached out to the city and said, we can't handle all this. You need to add more plans. And they did. And then in 1986, Bob Lynn and Mayor Koch then added 12 more plans. In 1992, the city and the Municipal Labor Committee, which is an umbrella group of unions, and that organization does not have a bargaining certificate and is made up of any union in the city of New York that is recognized by Office of Collective Bargaining to be a participant, which mostly holds administrative functions. But it is the unions with the collective bargaining certificates that has the power of collective bargaining. It is the unions in the city of New York that have the mandatory subject of collective bargaining, and one of those subjects is healthcare, not the MLC. Back in the 80s, the Municipal Labor Committee consisted of DC 37, which was led by Victor Gottbaum, another 100 unions behind them, but not the UFT. The UFT didn't come into the MLC until much later. I want to say it was the early 90s. And whenever Victor needed to get a 2/3 motion passed, he needed, obviously, the weight of his membership, which then was about 55,000 people, because you get one vote for every 250 members. That said, he needed a lot of votes in order to get what he needed. That motion passed. Today, between the United Federation of Teachers and DC 37, they can basically carry a 2/3 motion. And remember, the MLC does not have a bargaining certificate. They want to take the control, and I say they, as in the city of New York, of collective bargaining for healthcare away from the individual unions. But make no mistake, every dues-paying union member has that right, that their union should be working with them to fulfill their needs. And then, if they are going to vote on something in the MLC, cast the vote of the wishes of the members. When UFT Unity in the past few weeks has been attacking me and our organization, first, I laughed at it. Then it bothered me. And then it didn't. Because I remembered something my mother said. The UFT Unity Caucus is painting me as being an anti-union grifter or a Trojan horse trying to infiltrate their union. I laughed today about that because that's exactly, it shows that they have no substance to attack the issue. We're here because unfortunately a misguided union leader in 2014 chose to sell off retiree health benefits. The benefits for current retirees and for union workers, in-service workers, and not many people took notice. I have a labor relations degree. I am passionate about my union. I am passionate about unionism and what labor did to get to where we are today. I watch the union fights around the country, and I'm inspired by unions like the UAW, who are even organizing in the South, who are trying to create equality and equity everywhere they go, even in the South, whereas been typically anti-union. And here we are, and yet we're off, and I don't understand that. We shouldn't be making tiered benefits, and we shouldn't be privatizing the federal public health benefit of Medicare. That should definitely never happen. But unfortunately, in order to get a raise, and they're not the only union that did that, and I do blame the big insurance companies for this, they decided that the best way to get a raise was to sell off retiree health benefits and access to traditional Medicare, and force, or as they call it, auto-enroll, their retirees who weren't even in their unions anymore, because in the state of New York, you cannot be in a union if you're retired, force all those retirees into Medicare Advantage. On Tuesday, we received yet another favorable court decision, unanimous by the appellate court, that the city cannot force us into Medicare Advantage. And I want to show you this decision because it's very important and it's already being misused by people who have a personal agenda. We don't have a personal gain here. What we're trying to do is educate people as to what benefits that they're entitled to, that we were promised for almost 60 years, and that it should be up to the people that were supposed to protect us to continue to protect. In fighting this issue, we learned that we only had ourselves to rely upon because the people that we were trusting to protect us weren't there. We also knew from our labor history that the federal public health benefit of Medicare was created to allow everyone to have equal access to doctors and hospitals around the country. And that was important because we knew that Medicare Advantage plans, which were privatized, prevented our doctors in our hospitals, us access to our doctors in our hospitals. Many of them didn't accept the plan, and that became a problem. Now, if I can just grab this window and show you the court decision, I will make sure that I put it in the comments of this video. And Medicare, traditional, has very rare prior authorizations. So we knew already that by putting us into a managed healthcare system, we were going to have a problem getting access to the care that we needed. This is one of the major reasons why doctors and hospitals don't want to take Medicare Advantage plans. The burden that their offices have to go through for Medicare Advantage prior authorization is very difficult. And I think part of the issue too is who the retirees are and how they would be affected. We've been largely ignored on that front. So this is the decision. And I'll read this to you in part. And if I have time, I'll read you most of it. So this is the Supreme Court decision, the State of New York Appellate Division, First Department. There were 4 justices that were on the bench. One recused herself, and yet it was still a unanimous decision. The plaintiffs appeal from the judgment, denominated in order, of the Supreme Court of New York, Lyle Frank, entered September 19th of 2023, which in this hybrid proceeding class action brought pursuant to CPLR Article 78, granted the petition complaint to the extent of permanently enjoining the city respondents, defendants from eliminating the petitioner's plaintiff's retirees' existing health insurance, automatically enrolling them into a new Aetna Medicare Advantage plan, enforcing a June 30th, 2023 deadline for retirees to opt out of the new Medicare plan, and implementing any other aspect of the city's new retiree healthcare policy. Let me see if I could scroll that window down a little bit more. And of course, it doesn't want to work for me. Well, I'm not going to be able to move it, but I'm just going to continue to read it. And then I'll put the link inside the chat. Okay, continuing. The petitioners are retired New York City employees, including but not limited to teachers, firefighters, paramedics, and police officers, city retirees, and the New York City Organization of Public Service Retirees, US, which has tens of thousands of members. They commenced this litigation seeking to prevent respondents, the City of New York, and its relevant executives and agencies, collectively the city, from, among other things, discontinuing city retirees' existing city-funded Medicare supplemental insurance plans and automatically enrolling the city retirees in the Medicare, Aetna Medicare Advantage Plan, MAP. City retirees may opt out of the city plan, but then would be required to pay on their own their Medicare B premiums, which of course we were promised, and their Medicare supplemental insurance costs. In support of petitioners' request for injunctive relief, they submitted hundreds of affidavits from city retirees, former city officials, medical professionals, and healthcare experts, as well as thousands of pages of documentary evidence. Among these documents is the affidavit of Lilian Barrios Paoli, who during her 25 years working for the City of New York as Deputy Mayor for Health and Human Services, Commissioner of the Department of Aging, the heads of departments of Employment, Personnel, Housing and Preservation and Development, and Human Resources Administration. She states unequivocally that for more than 50 years, the city has promised employees that they would have a choice of healthcare plans in retirement, and that the access to traditional Medicare with a city-paid supplemental plan was always among those choices. Moreover, she states that city agency HR people reiterated this promise of choice to generations of prospective city employees. The guarantee of good healthcare in retirement, including the choice to participate in traditional Medicare with a city-paid supplemental plan, was an essential recruiting and retention tool. Individual retirees set out in their affidavits facts particular to them, which illustrated the statements made by Ms. Barrios Paoli. For example, city retiree Robert Benkowski worked for City Emergency Medical Services and the City of New York Fire Department from 1989 until his retirement in 2014. By the time he retired, he had developed kidney and lung disease, for which he is still being treated. He stated that the city made a clear and unambiguous promise that when I retired and became eligible for health insurance for Medicare, the city would provide and pay for a choice of Medicare supplemental health insurance. He states that he chose his healthcare providers based on his reliance on the city's promise and Medicare supplemental plan that he selected. The hospital where he's treated for complications following a kidney transplant and where he intends to undergo a second kidney transplant does not accept any Medicare Advantage plan for transplant surgeries. Similarly, retiree Phyllis Mintz, who worked as an assistant district attorney from January of 1996 until May of 2013, she stated that throughout her employment, the city repeatedly promised that when I retired and became eligible for Medicare, the city would pay for my Medicare B premium plus a choice of Medicare supplemental plan. This promise was made in job descriptions and other documents. The benefit was also promised verbally in my orientation process numerous times over the years by members of human resource staff and human resource staff during my retirement process. Ms. Mintz further stated that she relied on this promise in deciding to leave a much higher paying job as an associate at a large law firm to work for the city, in large part because the trade-off was a good one, because she knew that the promise of lifetime free Medicare B and Medigap was worth the significant financial sacrifice. She further stated that at least 3 of her healthcare providers do not accept the Aetna Medicare Advantage plan. She is considering returning to practice of law at age 75 in order to afford to opt out of the city's plan and pay Medigap insurance for herself and her husband. In their affidavits, many city retirees state that they relied on the language in the city's summary plan description books over the years, which promised a choice of Medigap insurance upon retirement. Like Ms. Mintz, many further state in their affidavits that city employees reiterated the promise to them, including but not limited to the employees of the New York City Housing Authority, Department of Design and Construction, Department of Sanitation, Health Department, Department of Education, Department of Corrections, the Office of Labor Relations, Employee Retirement System, District Attorney's Office, and the City University of New York. Like Mr. Benkowski and Ms. Mintz, many city retirees state in their affidavits that their chosen healthcare providers do not accept the Medicare Advantage plan, and accordingly, under the city's plan, many elderly or disabled city retirees would lose continuity of care for their often complex and serious health conditions. The affidavits of medical professionals and healthcare experts submitted by the petitioners explain that Medicare Advantage plans, unlike Medicare with Medigap, limit enrollees to in-network providers and require prior approval for treatment. They further state that enrollees' requests for prior approvals are frequently denied and that Aetna has the highest rate of denials in the industry, rejecting 12% of claims. The affidavits presented by petitioners describe the reasons that many providers do not accept Medicare Advantage plans at all, including delayed payment or no payment of patient claims, even after repeated submission of records and paperwork on the same claim. Prior authorization protocols that can delay care and lead to inappropriate denials of care. Furthermore, as petitioner experts note in their affidavits, there is no guarantee that city retirees who have moved out of New York and wish to opt out of the city's plan will be able to find a Medigap policy for which they are eligible or which they can afford. And since states have different rules applicable to Medigap insurance policies, the respondents dispute these claims in brief, but they did not present any evidence controverting them. Despite the petitioner's significant evidentiary submission, the city elected to submit only minimal evidence of their own and relied heavily on summary program description books for the city's health benefit program in various years. Notably, respondents submitted not a single affidavit by any city official disputing Ms. Barrios-Paoli's statements and thus effectively conceding them. The respondents consented that the Supreme Court could determine the petition and the petitioner's motion for preliminary injunction without argument on further submissions. The Supreme Court properly held that petitioners are entitled to relief under their promissory estoppel action. The city made clear, consistent, unambiguous representations, oral and written, over the course of more than 50 years, that City of New York municipal worker retirees would have the option of receiving their health care in the form of traditional Medicare with a city-paid supplemental plan. Consequently, the city cannot now mandate the proposed change, eliminating that choice. First, the record shows a clear and unambiguous promise made for more than 50 years in that upon employees' retirement, Medicare would provide the first level of hospital and medical insurance benefits, and the city benefit program would provide the second level to fill in the gap. This was demonstrated by each successive SPD and the affidavit of the city's own former Commissioner of Human Resources Administration, as well as affidavits from several hundred retirees naming the city employees who reiterated this promise. Second, the record shows detrimental reliance on the promise. Petitioners submitted unrebutted affidavits explaining that they chose to engage in public employment instead of working in the private sector, where they could have earned more money, in order to receive the promised health care. They also stated that where they chose to live was based on traditional Medicare availability and selected healthcare providers based on their participation in traditional Medicare, without needing to determine whether or not those providers accepted Medicare Advantage plans. Their reliance was reasonable and foreseeable, as it was based on more than 50 years of the city's representations and conduct providing traditional Medicare and Medigap insurance, which has remained far and away the most popular choice for retirees, even after the city began offering Medicare Advantage plans as another option. Third, Petitioners have demonstrated injury. Many city retirees stated that their chosen providers and hospitals, like many healthcare providers, do not accept Medicare Advantage plans. The city's plan to automatically enroll petitioners in the Medicare Advantage plan by Aetna and terminate their current Medigap coverage would result in injury to retirees whose medical providers do not accept the Aetna Medicare Advantage plan. Petitioners further state that opting out altogether, the other option under the city's plan, would cause them significant financial strain in funding their own Medigap coverage unless they receive reimbursements from the city of their Medicare B premium, which the city has declined to do. The city did not demonstrate otherwise. This is a singular case. This particular manner in which parties choose to litigate this action before the Supreme Court resulted in a record with significant evidentiary support for the petitioner's position and very little support for the respondent's position. That record and the arguments the parties chose to make on appeal lead to the conclusion that petitioners are entitled to relief under their promissory estoppel cause of action. However, the city did not violate the Administrative Code 12-126B1. There's no violation of the requirement that the city cover the entire cost of health insurance coverage for employees, retirees, and their dependents under that section. Such coverage, by definition, is provided by health and hospitalization insurance contracts entered into between the city and the insurance companies. Accordingly, the judgment denominated in order of the Supreme Court, New York County, Justice Lyle E. Frank, entered September 19th of 2023, which in this hybrid proceeding class action brought pursuant to CPLR Article 78, granted the petition complaint to the extent of permanently enjoining the city respondents, defendants, from eliminating petitioner plaintiffs' retirees' existing health insurance, automatically enrolling them into the new Aetna Medicare Advantage plan, enforcing a June 30, 2023 deadline for retirees to opt out of the new plan, and implementing any other aspect of the city's new healthcare plan should be affirmed without costs. Now, I want to say something because this is really important. We won this case. We've won now 9 cases. We've won 2 appeals levels at the first department. The mayor appealed our first case to the New York State Court of Appeals, the highest court. He will probably appeal this one too. Retirees are financing this entire case on their own off of their small pensions.